Afternoon, Madam President. So nice to see you up there today. Madam President, I move acceptance of the Joint Committee's favorable report and passage of the bill.
And the question is on passage. Will you remark?
I move adoption, Madam President.
Very good. Will you remark further?
Thank you. I would like to summarize the bill proposal that we have before us today, which essentially creates a fair process for determining whether or not a termination of a teacher should be upheld. The process now would replace a decision that could be made by a Board of Education with binding arbitration for a tenured teacher. It also establishes very clearly in the statute that the arbitrator, the impartial hearing officer, is required to use the just cause standard for making that determination. Just cause standard is something that is a well-accepted and well-understood term of art in arbitration proceedings. So currently we are in a position where we have teachers who could be terminated by a decision of a Board of Education. And in these very politicized times, that might not be a neutral and impartial and fair process. What we have done in this bill is made tenured teachers have the opportunity for an impartial hearing and a binding decision by that neutral arbitrator. I think it's critically important to note that every other unionized employee for the state and municipality have this right guaranteed, whether you're a police officer, whether you're a clerk, whether you're a firefighter. Every other employee has this binding arbitration by a neutral arbitrator procedure in place. And in this bill, we are making that true for teachers as well. I think it's a great bill, long overdue, and I urge passage.
Thank you. Will you remark further? Good afternoon, Senator Sampson.
Good afternoon, Madam President. Thank you for the recognition. I rise, I guess, to start off with to ask a few questions about the bill that is before us. I think the first step really is to kind of go through the bill just to make sure that we're on the same page about what actually is being accomplished here, what this bill does. I know that the good chairman and I, and the last couple of bills maybe didn't agree about what even the bill said, so I'd like to get that out of the way so we can at least agree on what is happening here and then decide whether or not that's good policy. And I know she did a good job of explaining the bill from the outset. I just want to make sure I have this completely clear. What's being described as just cause protection. I note that the term now appears in this proposed bill where it didn't appear in statute, but I'm just curious what the effect of adding those two words actually is. Through you, Madam President.
Thank you, Senator Kushner.
Thank you, Madam President. Through you, the just cause standard is a well-established test that neutral arbitrators apply when looking whether or not a termination should be upheld or should be overturned. And it is a long accepted test that arbitrators use. I do believe in impartial hearing officers currently, although that standard isn't spelled out in statute. It is typically what a hearing officer would refer to in making a decision on a discharge. So having it in law makes it directs the arbitrator, the neutral impartial hearing officer, to use that standard when determining whether or not a termination should be upheld or should be overturned.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the gentlelady and her answer. And that's a very, very valuable response, except it really doesn't get to the heart of what just cause actually means. If we're simply suggesting that it's long-standing and is what is used in binding arbitration, that's fine, except as was noted, it's not defined in the bill. So how do we know that the arbiter, the impartial hearing officer in this particular situation, is going to be applying a standard that can be known? I'm up here charged with the job of representing my constituents and voting on policy, and I'm being asked to make a determination whether or not we are going to apply a just cause standard in this particular case, and yet I'm not privy to what that means, and there is no definition in the bill. So I'd really just like to know, what is the just cause standard when being applied by binding arbitration that is, as the gentlelady said, widely accepted and commonplace through you?
Thank you, Senator Kushner.
Thank you, Madam President. The just cause standard, as I said, is an accepted standard used by impartial arbitrators throughout binding arbitration procedures. For instance, in any context of any contract, this term is used repeatedly, that there must be just cause for a discharge, and it is one that is well established and well understood. There are 7 tests of a just cause standard. I anticipated that the good senator might ask me about these, so I did come prepared, and I could read them all, but I know that would probably not be preferable, but I can quickly summarize. The standard is that you must be adequately warned, that the employer's rule or order must be reasonably related to efficient and safe operations. One test is that did the management investigate before administering the discipline? Was the investigation fair and objective? Did the investigation produce substantial evidence or proof of guilt? Were the rules, orders, and penalties applied even-handedly such that there was no discrimination? And was the penalty reasonably related to the offense? Those are the 7 tests of just cause in a termination case.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the good chairman and her desire to be forthcoming and have that information ready for us today. It's very much appreciated, and I think that's a very concrete answer that I'm satisfied with. Is there anything that this bill before us contains in statutory language that would suggest that that is the requirement placed upon the impartial hearing officer, that they must use the standard as described by the chairman through you?
Thank you, Senator Kushner.
Thank you, Madam President. Just as an arbitrator would look at a contract between 2 parties and see the words just cause and use that standard test for what just cause means, an arbitrator, which would be assigned per statute, would look at the statute to determine whether there is a just cause standard being required. And I believe that this language would provide for that instruction to the arbitrator.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that, and I'll accept that as legislative intent. I guess the following question I have really is that I note that this just cause language in the proposed bill before us seems to only be juxtaposed with the notion of termination. And I noticed that the definition of just cause that was just read included other types of discipline. Is there anything in this bill that would suggest that this just cause standard is going to be applied for other types of discipline for teachers, or is it simply a matter of a standard that would be required in the case of a termination through you?
Thank you, Senator Kushner.
Thank you, Madam President. It would only be for termination.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that. So what we've got here is effectively a change in the way the process currently exists. But I think we should just talk for a moment about what the current process is. Do teachers currently have protections in case the school district is attempting to terminate them, and what are they through you?
Thank you, Senator Kushner.
Thank you, Madam President, and through you, teachers currently have the ability to either go through an impartial hearing officer or a subcommittee of the Board of Education. That would then be the decision as to which procedure they would go forward with is up to the Board of Education. So it's either a hearing officer or a subcommittee of the board. They would go through that hearing, and then there would be a recommendation by either the hearing officer or the subcommittee of the board, and then the decision as to whether to uphold that recommendation or to differ with that recommendation is left up to the Board of Education. If the teacher feels that that decision was not satisfactory, they do have recourse to the Superior Court. Thank you, Madam President.
Thank you. Senator Sampson.
Thank you very much, Madam President. I appreciate the answer. Not really what I was driving at, although I do appreciate the final response, which was about the right of the appeal of the teacher. And certainly we're going to get into the change that this bill represents in the process from going from a choice made by the Board of Ed to have a subcommittee or impartial hearing officer to the elimination of the Board of Ed's involvement. But what I was driving at really was other types of protections that they might have versus somebody maybe in the private sector. My understanding is that teachers have protections, particularly if they're tenured. They also have typically union representation, which might come in the form of an attorney that would represent them in the case that they were being dismissed. They also have the current statute, which effectively limits the reasons by which a teacher could be fired to begin with. And it's a relatively narrowly tailored language that already exists. Just to edify the people listening, and me, who I think ought to know better, but I'm not really even sure what additional protections a teacher has for being tenured. I'm wondering if the gentlelady has an answer to that question through you.
Thank you, Senator Kushner.
Thank you, Madam President. Could you again repeat the question? It was at the tail end of a lot of other stuff.
Thank you, Senator Sampson.
Thank you, Madam President. I'm just kind of talking about the different types of protections that exist in place for teachers currently versus someone who works in the private sector. In Connecticut, we have at-will employment, for example. I mean, a typical job across our state that is not a union job and not a government job, for example, you could be terminated for any reason or no reason at all, and without any right to necessarily appeal that decision. An employer can just simply say, you know, sorry, Mr. Sampson, we no longer need you. And that's the end of your work arrangement. And what I'm suggesting here is that I believe that teachers already, prior to this bill being proposed, have a great many protections. They have a union representative, which might include an attorney to defend them in the case of a termination. They have the language of the current statute, which is very limited in nature, that lays out the reasons they can be terminated, which certainly doesn't include what it would include in the private sector, which is anything under the sun or no reason at all. No reason at all is not an option here. So right now, a school district couldn't simply just say we no longer need you. They would have to justify the reason for termination. And I was asking about tenure. It's a term we hear all the time, and presumably that comes with additional protections. And I was just asking if the good chairwoman knew what those protections were through you.
Thank you, Senator Kushner.
Thank you, Madam President. Through you, tenure does provide that a teacher cannot be terminated except with cause. However, the decision as to whether or not, under statute, the decision to whether or not there was cause to terminate that teacher is left at the discretion of the Board of Education. It is true that teachers in Connecticut, by and large, are are unionized, and by virtue of their union contracts, they have other protections as well. They're built in through the collective bargaining agreement. But with regard to termination, it's governed by statute, and this bill changes the statute to provide for binding arbitration for teachers, as is provided for other employees that are unionized within our state, whether it's state or municipal employees. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. And I thank the gentlelady for those comments. I think we've satisfied the first test that I laid out at the start of this conversation, which is that I wanted to make sure that we agreed on what the bill actually does, and I think we do. We agree that this bill is going to change the standard by which teachers can be terminated to require just cause. And the other piece of it, which we haven't talked so much about but I know has been referred to by the good chairman, is the notion that under the current law, what happens is the school district has the ability to set up a subcommittee to review a termination, or they can choose an impartial hearing officer. But at the end of the day, regardless of whether they have the subcommittee or the impartial hearing officer, it's really up to the Board of Ed to make the final determination. And under this bill, if this becomes law, what will happen is that Board of Education will no longer have a say at all. They will not be the ultimate decider, because that subcommittee will no longer be allowed to participate, or I don't know if it can exist at all, but that's kind of irrelevant. But what will happen is we will just be left with the impartial hearing officer, and that impartial hearing officer's decision will be binding on the parties, that educator and also the school district. And the gentlelady's used the term binding arbitration several times, and that's what it is, effectively. It's binding arbitration. Something that I've never really agreed with, especially when it comes to a public sector position, because in my view, the school district exists at the will of the people who live in that school district. You know, the people who live in any particular school district are electing a Board of Education. That Board of Education is who hires the superintendent of schools. Ultimately, they're the ones that make the determination about hiring all of the teachers. I think it's a very interesting way to look at the world, that you can have the power to hire someone but then not have the power to fire them. And yet that's what would be happening in this bill, is we would not be taking away the right of school district representatives in the form of the Board of Education to have the power to hire a teacher, but they'd no longer have the power to fire them. The only person that ultimately would be able to fire someone in this particular situation is, in fact, this impartial third party. So I think we are in agreement about what the bill actually does. The question now is whether that's good policy or not. And I'll tell you, just from a personal standpoint, my fiance is a school teacher, and you know, I asked her about this. In fact, I took a kind of a unscientific poll, let's say, of her and a couple of teachers that she knows closely, and the three of them all agreed with me that they didn't think this was necessary, that teachers already have significant protections over typical employees. And the concern that they expressed to me was that this might have the potential of actually protecting bad teachers. And because presumably they believe they are good teachers, and I have no doubt about that, they want to make sure that good teachers are protected. But they're less concerned with folks that might not be achieving. And I'll just take a moment to point out, you know, that we talk a lot in this chamber about the quality of education and how important that is to us as lawmakers and how important it is to our constituents. But frankly, the amount of people that are being allowed to graduate high school in the state of Connecticut without being able to read is frightening. There are statistics that bear this out. Connecticut's math score in 23-24 on the state performance index was only 60.2, and that number is down from 2019 and well below the target score that schools nationally are expected to follow, which is 75. They scored 61.8 in science, 63.9 in language arts. Every one of these numbers, and I've got more, you can go through this list, they have fallen in recent years. The quality of education in Connecticut is actually diminishing, sadly. In 2018 and 19, 89% of freshmen were on track to graduate. That percentage dropped to 82% in 22 and 23. And there's more statistics. I just don't want to belabor the point. I think people understand what I'm saying here, which is that, I'm as concerned about the quality of education as any person in this room, and certainly the people that I represent. And I think it's incumbent upon us that when we're looking at any type of policy that affects education, we have to ask, is this going to end up with a net better result for the quality of education, or could this cause more harm? And I'm not suggesting that this is the end-all, beat-all policy that's going to make any significant difference. But I do believe that the quality of teachers has a lot to do with the quality of education. How could it not? And if we're here providing additional protections that may have the net effect of allowing teachers that are less than the stellar quality of the majority of teachers that are out there, then is that really a good policy? And that's what I'm asking myself here, because in my view, what teachers do is a tremendously important and, in fact, noble work. I can't think of too many more occupations that are more deserving of respect and accolades than someone that, frankly, probably makes less pay than they might in a lot of other jobs, to go through the difficult task of dealing with young people, and in some cases and in some places, no doubt that is a challenge. And they do that because they have an innate desire to want to better the world and improve the quality of lives of young people in our society at large. So for me, it's an important question. What do we do to improve the quality of education? And for me, this is a tough decision because I want to make sure that teachers understand that I am behind them, that I have their back. But I'm more concerned with quality teachers having the ability to do their job the best that they can possibly do it, that quality teachers deserve and receive the respect that is necessary for them to be able to fulfill their jobs in a way that they can accomplish their tasks. I know that we, as a body, tend to impose a tremendous amount of requirements on school districts in the form of mandates and filling out forms and procedures that have to be followed, and it seems like every year we're adding things to school districts that have very little to do with education itself. And those things frustrate me, because for me, I would like to see us pass more and more legislation that empowers teachers to actually be teachers and be the decider in the classroom. And that includes on disciplinary issues. And I'll talk more about that in a few minutes. But I just wanted to stop here to just reflect, publicly about how difficult this type of vote is and what kind of decision this is, where I want to stand behind this select and important population, but I also want to measure whether this is good policy or not based on what's happening here. What will change in the world if this bill becomes law? So, there is the issue also of collective bargaining. It was noted earlier that other public employees and other unionized employees have the benefit of collective bargaining, where they are posed opposite the employer in a situation where they negotiate the terms collectively rather than individually, like most people in the private sector do, except those unionized folks in the private sector also. Public sector public sector unionized employees, in my view, get a lot of extra benefits. And one of the benefits that they've received in recent years is an aggressive Democratic majority legislature that's willing to come to the state capitol to put forth policy into statute that would normally be collectively bargained. And we see it repeatedly. There's numerous examples every year of the Labor Committee taking up policy that's been previously collectively bargained, and instead of allowing the parties to engage in a negotiation and determine whether something belongs in their contract, we're taking away that opportunity by placing it into law. And this is another example. You know, this situation is very clear to me. The labor unions that represent teachers in the state of Connecticut could very easily come forward and require that in their contracts that this just cause protection with the binding arbitration piece be included in that contract, and yet they have not. Instead, they're asking the legislature to intervene and to take the side of one party in that negotiation. And for me, that should be a difficult question for every person who serves in this chamber, because you're being asked to take a side here. And the side you're asked to be taking is you're either going to take the side of the teachers by providing this additional protection, or you're going to have to take the side of the town that you represent, or towns. And many of us represent multiple towns in the state. I represent 5. And I can tell you that if I went to the town governments in those 5 towns, they would say, no, we don't want this bill. This bill will take away our right to act on behalf of the residents that we represent in making a decision about whether a teacher stays employed. So this is a tough question. Do we want to put ourselves in a position of diminishing and limiting the rights of the governing bodies of the towns that we represent in the case of a termination of a teacher they feel needs to be fired? I will tell you that in my case, I trust my town governments when they make a determination like that. I don't think that the town governments that are in the towns that I represent would just arbitrarily decide that they're going to fire a teacher for political causes, which I think was what the good chairman alluded to at the start of this conversation. I think they would rightfully follow the existing statute, which we can look at because it's also contained in the proposed bill, and it is on lines, beginning on lines 38, which is a very long paragraph that goes several pages. I don't know if you can consider that still a paragraph, actually, after it goes over multiple pages, but that's the way it's drafted. But there is a list of reasons that you can terminate a teacher for. So in my view, is there anything in the current statute that would allow a school district to terminate an employee based on their political views? Through you, Madam President.
Thank you, Senator Kushner.
Thank you, Madam President. Through you, the current statute, just to be clear, prohibits a union to collectively bargain for binding arbitration in their contract. So I think that's very important to note, that this change in statute will provide for that process, but with the existing statute, a union is prohibited from negotiating, as was suggested by the good senator, for binding arbitration. I also want to comment that additionally, even with this change in statute, the superintendent and Board of Ed could fire someone. What this changes is they have to establish that there was just cause for that termination. I think that the statute is clear that there are a number of reasons currently that a teacher can be terminated, and they are articulated here, and there is a process here. But what is clear in existing statute is that the decision of the Board of Education is final and binding, not of a neutral recommendation by a neutral hearing officer, not even of a recommendation by a subcommittee of the board. And that applies whether or not the recommendation is to uphold the discharge or whether it is to override the termination. It is ultimately in statute up to the Board of Education. So there are reasons provided in statute where a person can be terminated. Those reasons in statute would continue, would stay, and the only difference now is that there would be the requirement that the just cause standard is used and that that decision of the arbitrator be final and binding. Through you, Madam President.
Thank you, Senator Sampson.
And thank you very much, Madam President. I will ask the question again because I don't think the gentlelady heard my question, which was, is there anything in the current law that would allow a school district to terminate a teacher for their political views? Through you.
Thank you, Senator Kushner.
Thank you, Madam President, and I think my answer was responsive. My answer is there are a number of reasons that someone could be terminated, but regardless of whatever reasons are in statute, this statute currently provides the opportunity for a Board of Education or a superintendent to terminate an employee for any reason.
Thank you, Senator Sampson.
Thank you very much, Madam President. I have great respect for my colleague, but I beg to differ. I don't think the answer was responsive the first or second time. There is a list of reasons, I will agree, in the bill that says why you can terminate a teacher, but I had a very specific question, which is, can you terminate a teacher for their political views? And the reason why I asked that question is because in her opening statement, she said that there is a lot of political turbulence, and I'm paraphrasing, I don't know that I used that word, but there were concerns in society today, and I think she did allude to people's political views being a motivation to eliminate a teacher. And if I'm mistaken about that, I encourage her to correct me. But if that's the case, and that's the argument for why this is necessary, I'd like to get to the bottom of whether that's true or not, and I don't think it is. Because I'm looking at the current statute and I'm looking at the enumerated reasons for why you can terminate a teacher, and that is not among them. I also want to thank the gentlelady for explaining something I did not know, which is that binding arbitration apparently is not allowed to be negotiated for by collective bargaining in the case of teachers. And I think that's very interesting. And it simply has me just thinking to myself, gee, I wonder why that is. I think it's because whoever wrote that statute realized that binding arbitration in this particular case would not be just and proper. I think that they recognize that fully, which is why they put that right in our statute to say, no, 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 we should not have binding arbitration in this particular case. And I bet you the reason why they felt that way is the same reason why I feel that way, which is that it's the school district that's hiring this individual. It's the school district that has the expectations about what their duties and responsibilities are and how they will perform as a teacher. And if they fail to live up to those standards, then it should be up to that school district to determine when that teacher has no longer satisfied those requirements. Not some arbitrary, unknown third party, which is effectively what's being created here. So, for me, that's an issue. It all boils down to local control. Do you believe in local control? If you believe in local control, then you should have a problem with this policy change. Because we, as citizens, elect local government to make decisions for us on the way our towns are run. They make decisions about how much money to spend on the public works crew. They make decisions on when the roads are going to get repaved. They make decisions about how well maintained the park is. They make decisions about everything under the sun, planning and zoning. Think of the town boards and commissions. You can just go through the list. They make decisions on all of those factors for us. And our system is based on this beautiful notion of representation, that we choose people from within our community to represent us. We give them the power to represent and make choices for us, but they do it with the complete and utter understanding that we are there putting them in that position, and that they have a responsibility to us because we voted for them. And we also have the ability to vote them out if they fail to do so. You cannot vote out an impartial hearing officer. If you have a school district that does something dumb, frankly, they fire a good teacher for a bad reason, you actually have some control over that. Under the current law, you can just not elect that Board of Education again. If this becomes law, you will lose a say that you have right now as a citizen in the great state of Connecticut. You will lose the ability to have a say over whether a teacher is fired or not. You lose that right. This bill takes away your right as an individual citizen to play a part in whether or not that teacher's, I was going to say tenure, I don't want to misspeak by using that term, status as employed with that school district is affected. I just want to make sure that sinks in for everyone. It's also a matter of whether or not you believe that local control is a proper and worthy form of government. And I know of none better. The alternative is either some larger, higher level, centralized government making broader decisions that govern larger territories, which is why we end up with state departments of education and federal departments of education. And I think that's problematic because what they're doing is effectively they're trying to make policy that spans all types of different situations. Clearly, the education requirements in the city of Waterbury is entirely different to the town of Wolcott, right next door, two towns I represent. So for me, I would much rather have those two communities having their own boards of education that are responsible to their constituents right there in their communities making the decisions. I'm not so much in favor of having a top-down central planning type large government entity making decisions. And worse than that would be a bureaucracy making decisions. Unelected people making decisions that affect the lives and the rights of people across Connecticut. Madam President, a question for the proponent. Is this really an issue right now? Is there a rash of teachers being terminated for light and transient causes, say, through you, Madam President?
Thank you, Senator Kushner.
Thank you, Madam President. Through you, I am not, this did not arise from a rash of sudden firings. This is something that we determined needed to be addressed. It is not responsive to any one particular incident. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Just that being the case, all in the same, can I ask if there is at least one example of an incident that this might address through you?
Thank you, Senator Kushner.
Thank you, Madam President. I did not come to the chamber equipped with examples of egregious behaviors by any Board of Education. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that. I was wondering because I tried to do a little Google searching myself, and I couldn't find a single example of a teacher being fired for cause that was in dispute in Connecticut. At least not in my search. I don't know if I could say going back any particular number of years, but it's certainly not something that's in the headlines every day. In fact, I don't think it's happening at all. Which begs the question: why is this before us? And I think I know the reason to that, and that is simply that there is a desire on behalf of the majority to move the needle in favor of labor any chance that comes up. Effectively, that is how the majority sees the purpose of the Labor Committee, which is to take the side of labor and to push policy into law that would benefit labor at the expense of employers, even in the case of public employers like the state or municipalities. I think that's the reason why we have this legislation. I don't think that's a justifiable reason, though, frankly. I think that we have other problems in education, as I mentioned. The quality of education is at stake. And that is what we ought to be doing today, is finding ways to actually hold institutions of education more accountable to providing a quality education and not protecting what could be teachers that are failing at their job. And again, I'm trying to be very careful about my language here because I will repeat, I have tremendous respect for this noble profession. I am very close with many teachers. But frankly, they feel as I do. One of the constant concerns I hear from the teachers that I know is that they're frustrated that bad teachers are protected. They don't like to see bad teachers protected. They want to see good teachers respected and advanced. That's what they want. And they want to see standards increase so that the quality of teachers increases generally, and then the quality of education increases as a direct result. Madam President, can I ask, was there any testimony on this bill in the committee through you?
Thank you. Senator Kushner.
Thank you, Madam President. There was testimony on this issue, and I think the good senator and anyone listening who's interested can find it as a part of the formal record of the public hearing. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. Does the gentlelady have any additional information, like who testified, how many people testified, what did they say, were they for or against the bill through you?
Thank you, Senator Kushner.
Thank you, Madam President. I did not prepare a list of the number of people who testified in favor or against this bill. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. That's unfortunate, but I've come to save the day because I actually did grab that information for this debate today. And I will be honest with the folks in the chamber, it was not a big deal. There were only 2 individual pieces of testimony submitted on this bill. Shocking. You would think an issue like this that is affecting the lives of an entire occupation in our state and is going to interfere with the rights of every citizen in this state having a say over who the educators in their respective school districts are. You'd think many, many more people would be interested in the outcome. But yet we had only 2 pieces of testimony. One of the testimony items is from the Commissioner of the Department of Consumer Protection. Actually, am I incorrect about this? Maybe I'm looking at the wrong bill. I think I have the wrong item that was printed out for me. Well, that's a shame. I do have the other item, though. The other item is the State Department of Education, and that is the Commissioner of the State Department of Education. And she says, quote unquote, this is Commissioner Charlene M. Russell Tucker of the State Department of Education. She says the proposed change to the statute 10-151D would invest that power in a single arbitrator, thereby depriving local and regional school boards of the right to make the fundamental determination as to the conduct of individuals who teach in their systems and interact with their students. And I'm realizing I may have misspoken about the number of items of testimony because I have multiple bills I'm debating today, and it's a different bill that only had the 2 items. So I am completely mistaken on that, and I am very sorry for making that comment. However, it still stands that the State Department of Education did testify on this bill, and they did testify in opposition. And what's even more remarkable is they testified in opposition for the exact reason that I'm arguing this bill right now, which is in preservation of our system of representative government. That's why the State Department of Education opposed this bill. I got to tell you, I'm enthusiastic about such a thing occurring, because this is a rare situation. You know, one of my concerns would be the bureaucracy of the State Department of Education wanting to impose its will on individual school districts, and here I'm aligned. I am aligned with the Commissioner of the State Department of Education, who also agrees that ultimately the final say should be the school district itself. The elected people in that community should be the ones that actually make that determination. So I'm going to offer a couple of amendments, I think, as a mechanism to further this debate. So, Madam President, through you, I have LCO 8413. I ask that the clerk call this amendment, and I be given leave of the chamber to summarize.
Mr. Clerk.
LCL number 8413, Senate Amendment A.
Senator Sampson.
Thank you very much, Madam President. This amendment is a very straightforward amendment, although if you're looking at it, it's not very intuitive. But what it does is effectively removes all of the changes to the current statute that would eliminate the right of the school district to create and empower a subcommittee of the Board of Education to review a termination of a school teacher. And I think it's a smart change. It would leave and preserve the change to the just cause standard, but it would require that the school district itself maintains its final authority to make the final decision, which I think is imperative from a standpoint of good public policy. I move adoption, Madam President, and when the vote is taken, I ask that it be taken by roll. Thank you.
Thank you. We will indeed have a roll call vote as you requested. Will you remark further on the amendment before the chamber? Senator Kushner.
Thank you, Madam President. I believe that this amendment largely undoes the purpose of this bill, with the exception of maintaining the just cause standard. It does remove impartial decision by a binding decision by an impartial hearing officer, and that is at the core of what we are doing today. So I would urge my colleagues to vote no on the amendment.
Thank you. Will you remark further on the amendment? Will you remark further? If not, the machine is open. Mr. Clerk.
Immediate roll call vote has been ordered in the Senate. The immediate roll call vote has been ordered in the Senate. Voting on Senate Amendment A. Senate Bill number 1371, an act establishing a just cause standard for teacher contract termination, requiring contract termination hearing for teachers that have attained tenure before a neutral hearing officer. We're voting on the amendment. This is not the bill. We're voting on the amendment. Immediate roll call vote.
Have all the senators voted? The machine is locked. Mr. Clerk, would you kindly give us the tally, please?
Senate Amendment A, Senate Bill 1371. Total number voting 34, total voting yea 9, total voting nay 25, absent not voting 2.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. Unfortunate to see that amendment fail. It looks like a mostly party line vote. And for the reasons that I've just described, which is that, you know, for me, the just cause piece of the conversation is one aspect of it. But for me, the bigger issue was really the elimination of the local control aspect of this bill as it's been proposed, which is to take away something that I think is inherent in the right of school districts, which is that, you know, the school district is there to serve their population, the kids that live in that community, that are educated in that community, and the local school district, in my view, should have ultimate authority to determine pretty much everything. I mean, from curriculum to disciplinary action to you name it, pretty much across the board. And that includes the hiring of all the staff, all the teachers, all the administrators, and therefore, because as I mentioned a little while ago, it only makes sense that the person who's responsible to hire someone should be the person responsible for firing them. And this bill, as it currently stands, will ultimately take away that right from the school district. And therefore take it away from the people that live in that community and the teachers and parents that live in that community too. It's all going to be left up to just one person. That's what binding arbitration does, is it takes away the rights of the parties that are actually invested and hands it over based on this argument that this person is impartial, but we don't know anything about them. We don't know what their motivation is, or whether they have a political motivation for making a determination. And certainly they'll be required not to, but when you say that their decision is binding, that means it overrides everyone else's opinion. And for me, that's problematic. And it's too bad, because I was hoping that we could find a way to compromise on this bill so that I could end up supporting it, because I'd like very much to be able to say that we've made some incremental change in the protection of teachers that I could support. And unfortunately, the failure of my amendment, that I think would have been a much more reasonable way to go ahead and move forward with such a policy, has failed. I'm going to offer another amendment in a moment, Madam President, and I just want to preface it by restating the fact that I do believe there's a lot of things that we can do to help teachers. I don't think that this just cause or binding arbitration protection is high on the list for most teachers. As I mentioned, I did kind of an informal poll with the teachers that I know, and this wasn't even on their radar. They're like, yeah. In fact, you know, last week there were a number of teachers here for the purpose of lobbying this bill. They were outside and I was talking to them, and, you know, of course they were certainly in favor of the bill, but as we started talking, it became clear that this was not the number one thing that mattered to them. I started asking them about other things. You know, what else can we do? What's something that actually would make a difference to you in your career? And we started talking about the bill that passed both chambers a couple of years ago. I think it was in 2023. It was a bill that actually would have empowered teachers in the classroom to make disciplinary decisions. This is something that I think is failing in school districts all across Connecticut, which is that teachers are being disarmed effectively. They're being stuck in a hard place between administrators and parents, and they don't have the opportunity necessary to have their views expressed in a way that you know, someone's arguing on their behalf. And I think that's a failure of the way our system currently operates. And it was a shame that that bill went through both chambers. I can't remember whether it was unanimous. It was very close to that, if not. I know that vast numbers of members in both chambers, in both parties, voted in favor of empowering teachers, but unfortunately it was vetoed by the governor. And I think we may have had the numbers to override it, but it didn't happen. But I just want to revisit that today. Because in this whole conversation, I guess my personal frustration is that I'm going to be on the record at the end of this discussion voting against this bill. And I really, you know, it's not fair, I think, frankly, because I'm somebody who supports teachers. I'm somebody who wants to see them, let's say, recognized, appreciated, honored for the noble work that they do. That really does matter to me. But that's not a reason for me to vote for what I think is bad policy that deprives the local community of the control of making sure of the status of teachers in their district and handing it over to a binding arbitrator. So in an effort to illustrate my desire to do something on behalf of teachers that will show and what I believe is an important symbol of my desire to improve the situation on something that I know that they care about even more than the bill that is before us, I have this amendment. Madam President, it is LCO 8797. I ask, as always, that the clerk call this amendment, and I be given leave of the chamber to summarize.
Mr. Clerk.
LCO number 8797, Senate Amendment B.
We'll get it up on the board, Senator, and then there you go. Thank you, Senator Sampson.
Thank you very much, Madam President. This is a pretty straightforward amendment, and I'm going to encourage my colleagues in the majority to support it. It's not consequential today because it is a task force, but I think that the mere creation of this task force will get us farther along in the process of getting us to an end result. And what this task force is about is a study and make recommendations concerning classroom behavior and school discipline. It's focused very narrowly on the same subject that I just referred to, which is that bill that we passed a couple of years ago that empowered teachers to have more say about discipline in the classroom. I think this is key. I think it's very important to not only protecting teachers' safety, which I think is like the obvious and paramount reason for wanting to do this, but also because I think it shows symbolically that we respect and appreciate teachers, and they shouldn't just be wedged in between parents and administrators in difficult positions sometimes. And finally, because I want to see more people desire to get into the profession. These are three really good reasons to support this amendment. And it's very straightforward. Again, I'll summarize the amendment. That's supposed to be what I'm doing, which is to create a task force to study and make recommendations concerning classroom behavior and school discipline. And the task force will consist of a number of different parties. And I wanted to just make note of that. I was purposeful in including a representative of each of the two major teachers' unions in the state. There would be a representative of the Connecticut Education Association, as well as the American Federation of Teachers, Connecticut. I also included a representative of the Connecticut Association of Public School Superintendents, that's CAPS, a parent or guardian of a student, a high school student themselves, and a representative of the Connecticut Association of Boards of Education, that's CABE, the Commissioner of Education, and the Child Advocate. I think that's a good selection of people for a task force to put together to tackle what I think is a super important issue, maybe far more important than the underlying bill itself. I move adoption, Madam President, and I'd love a roll call vote when we take that vote. Thank you.
And we will have a roll call vote. Senator Kushner, would you like to remark on the amendment? We will put the chamber at ease. We'll stand at ease for a moment. Senator Kushner.
Thank you, Madam President. Through you, I do want to comment on the amendment that was just introduced by the good senator. While I don't object to the idea of addressing classroom behavior, and I do recognize that's important to our teachers, I'd be happy to discuss that at any time at a later date and consider that kind of policy decision, although I do believe it would be most appropriate before the Education Committee. But I was for a moment hopeful that I thought I heard the good senator say that if maybe we would have agreement on the underlying bill proposal if we agreed on this amendment. Unfortunately, that was not the case. So at this time, I would urge my colleagues to vote no on the amendment. Thank you, Madam President.
Thank you. Will you remark further on the amendment? If not, the machine is open. Mr. Clerk.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate. We're once again voting on an amendment. This is not the bill. This is Senate Amendment B of Senate Bill 1371, enact the establishment of just cause standard for teacher contract termination, requiring contract termination hearings for teachers that have attained tenure before a neutral hearing officer. An immediate roll call vote in the Senate on Senate Amendment B of Senate Bill number 1371.
Have all the senators voted? Machine is locked. Mr. Clerk, give us the tally if you would, please.
Senate Amendment B of Senate Bill 1371. Total number voted 34. Total voting yea 11. Total voting nay 23. Absent not voting 2.
Amendment fails. Senator Sampson.
Thank you very much, Madam President. Frankly, I'm stunned that amendment failed on a party line. You know, I went into this debate with every desire to try and find a means to be able to come together and create a bipartisan compromise, to be able to move policy forward that we could agree to universally. And, you know, my desire with the previous amendment was to maintain at least the substance of the title of the bill and the proposal that had been put before us by maintaining the just cause protections that were being advanced. My objection was over the elimination of the rights of the local Board of Education and therefore effectively the rights of the citizens of that district to be able to participate in that process, and replacing that with binding arbitration where one person gets to decide. For me, that was the big stumbling block, and it's very unfortunate, as I mentioned before. I mean, had we adopted that amendment, I certainly would have been willing to support the bill. Just in clarification to the gentlelady's comments earlier, that's what I agreed to support the bill if we adopted the first amendment. But this amendment was an entirely different situation. This is something that I think we should universally agree on, which is that we should revisit that legislation from a couple of years ago that would empower teachers in the classroom. I went so far as to include the two major employment unions for school teachers in the state as part of the task force in an interest of trying to reach across the aisle and create some bipartisanship to advance that. So I got to tell you, I'm shocked that we couldn't get that over the finish line. The gentlelady said that she thought it was a good idea, just not today. And my question to that is just why not today? You know, it seems like this is long overdue, in fact, and we should be addressing it. So this leaves me at this point, after offering my two amendments and failing, with having to make a decision about how I'm going to vote on the bill as it was originally offered. And I sadly am stuck with the same concerns that I began with, which is that I don't, number one, feel like that there's a problem in the state of Connecticut right now. I asked, and there were no examples of teachers being terminated without cause. There's no rash of terminations. In fact, my understanding is that teachers are highly sought after in the state of Connecticut economy currently. It would be very difficult to lose your job as a school teacher. And ultimately, I think the votes on the amendments are almost an indication of what's really driving this policy forward, which it's very clear to me. And I hope people that were watching this understand that I think that the focus on this bill is much less about teachers and protecting good teachers from being terminated, and it's more about advancing the cause of organized labor. For me, it's very clear that that's what this bill is about. It's about finding a way to insert binding arbitration in yet another area of state and local government, and less about protecting teachers. I came to this debate with a desire to protect teachers. I offered two amendments designed to protect teachers. And sadly, both of those amendments failed. And now I'm left with a choice where I can kind of protect teachers by inserting this just cause language, but I also, if I do that, I have to also tell the people back home in my districts, the towns that I represent, that their local boards of education have no say in who the teachers are in the classrooms, in our schools, in our towns. That ultimately that decision will be decided by an impartial hearing officer through the process of binding arbitration. And I don't agree. I think one of the greatest aspects of our system as Americans is representative government. And anything that comes along in the form of a policy or a bureaucratic statement or some sort of executive branch declaration that denies that representative system, I'm going to stand in opposition to every time. And I'm going to stand in opposition today as well, Madam President. I just can't see my way through to support this bill knowing that it is denying the rights of the people I represent to have a say in the education systems that teach their children. Thank you very much.
Thank you. Will you remark further on the bill?
Hello?
Oh, Senator Kissel. If not, the machine is open, Mr. Clerk.
Immediate roll call vote has been ordered in the Senate. An immediate roll call vote has been ordered in the Senate. We're voting on Senate Bill number 1371, an act establishing a just cause standard for teacher contract terminations and requiring contract termination hearing for teachers that have attained tenure be before a neutral hearing officer. We're now voting on the bill. This is Senate Bill number 1371. Senate Bill number 1371. An immediate roll call vote in the Senate on Senate Bill number 1371.
Have all the senators voted? The machine is locked. Mr. Clerk, would you please give us the tally?
Senate Bill 1371, total number voting 35, total voting 827, total voting 88, absent not voting 1.
Legislation passes. Mr. Clerk.